This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'm going to talk about the fact that CGLs are third-party liability policies. They do not cover direct physical losses. They are not first-party policies. And a judgment awarding damages is needed for a CGL to provide coverage and to pay. Hausmann Construction, Incorporated, appealed the district court's grant of summary judgment to Nationwide Mutual Insurance Company on Hausmann's breach of contract claim. In Hausmann Construction v. Nationwide, a February 22, 2023 decision of the Court of Appeals of Iowa, the Court of Appeals resolved the dispute by stating the basic facts of the case were that in 2017, Iowa Western Community College entered into a contract with Hausmann for the construction of a new wellness facility on the college's campus. The contract provided Hausmann would be responsible for property damage arising during the construction process. Hausmann entered into a subcontract with Advanced Trenching and Utilities, LLC, for utility and excavation work on the project. The subcontractor agreement provided that Advanced Trenching would be responsible for property damage arising from its work. Additionally, Advanced Trenching was required to include Hausmann as an additional insured under its insurance policy, which it did. Advanced Trenching entered into a subcontract with Torco Enterprises, Inc. Torco's employees struck a water main while performing work on the project, rupturing the water main and causing flooding of the work site. Hausmann paid $199,509.54, the cost and expenses for repairing the water main and replacing the damaged retaining wall. Hausmann asked Advanced Trenching to submit a claim to Nationwide for damages, but Advanced Trenching refused. Hausmann then submitted a claim to Nationwide, claiming it was covered by Advanced Trenching's policy with Nationwide as an additional insured. Hausmann sued Nationwide, claiming there was a breach of contract because Nationwide refused to pay. Nationwide filed a motion for summary judgment and argued that the lawsuit was a direct action against an insurer, which is prohibited by Iowa Code Section 516.1. Nationwide pointed out that Hausmann had not obtained a judgment against Advanced Trenching or Torco, and it would be premature to permit Hausmann to collect from Nationwide the costs and expenses of repairs due to the water main break. Nationwide also stated that although Hausmann was an additional insured, it did not allege that Nationwide breached any duty to defend or indemnify Hausmann as an additional insured. The district court obviously granted Nationwide's motion for summary judgment. The court determined that the phrase legally obligated to pay as damages meant sums resulting from a legal action by a third party on the additional insured. The court noted the college did not make a claim against Hausmann, and there were no damages proven against Hausmann by a third party in a lawsuit. The court also concluded that Hausmann's claims against Nationwide were barred by Iowa Section 516.1. Hausmann's claims against Nationwide are distinct and severable from its claims against Advanced Trenching and Torco. Hausmann claimed Advanced Trenching and Torco were negligent in performing their work. Additionally, Hausmann claimed Advanced Trenching abandoned its work, failed to act in a good and workmanlike manner, breached the subcontract agreement, and breached implied warranties. Hausmann's claims against Advanced Trenching and Torco arose from their work on the construction site for the wellness facility. Hausmann's claims against Nationwide arose from the terms of the insurance policy and are distinct and severable from the claims against Advanced Trenching and Torco. The district court ruled, quote, if Hausmann wants to seek remedy for its expenses in relation to the water main break, it still has the opportunity to prove recovery against Advanced Trenching or Torco, since the incident itself lies in tort action. This would put Hausmann in the position that Nationwide presumed it would be in, as the insurer of Advanced Trenching. Nationwide sought to have the action dismissed as a violation of Iowa Code Section 516.1 because a third party's direct action against an insurer is barred by the statute. Hausmann is effectively prevented from bringing claims against Nationwide at this time. To the extent Hausmann's claim against Nationwide is an attempt to circumvent its claims against Advanced Trenching as a tortfeasor and proceed directly against Advanced Trenching's insurance company instead, the district court correctly ruled that the claim is barred by state statute until such time as Hausmann obtains a judgment against Advanced Trenching and the judgment remains unsatisfied. Hausmann had the initial burden of showing that its claim falls within the policy's coverage. Hausmann claims that it was legally obligated to pay the amount it did to fix the damages caused by the water main break. Nationwide countered that no one asserted any claims against Hausmann, so Hausmann voluntarily decision to pay for the repairs does not make the payment a sum that Hausmann was legally obligated to pay as damages. Based on the arguments of the policies, the case hinges on what becomes legally obligated to pay as damages means. In common usage, the noun damages has a specific meaning in a legal context, such as in this case, where a legal obligation is involved. The phrase legally obligated to pay as damages in the CGL policy is not ambiguous. A contractual duty to incur the repair costs without more is not sufficient to bring the repair costs within the scope of the CGL policy's insuring agreement. No one demanded Hausmann pay the cost of repairing the damage from the water main break, and there was no claim, order, or adjudication requiring them to do so. As such, there was no coercive legal obligation for Hausmann to pay. Therefore, there is no coverage for the repair costs Hausmann incurred, and the district court got it right in granting summary judgment on that basis. As the district court properly granted summary judgment in favor of Nationwide, the trial court's decision was affirmed. In my opinion, a CGL policy, whether to a named insured or an additional insured like Hausmann, is a third-party liability policy and can only respond to a claim or a judgment made against the person or entity insured. No one made a claim against Hausmann. Hausmann did nothing that would result in a claim. It paid to keep its customer happy. It could only obtain coverage for defense or indemnity if a claim was made against Hausmann, a suit filed against Hausmann, or a judgment entered against Hausmann. Since no claims were made, no judgment was entered, Hausmann had no claim against the CGL, and the trial court was clearly correct. Hausmann sued its insurance company because it thought it could get more than the $200,000 it paid to repair the water leak. What it should have done was sue its subcontractors, all of whom were insured by Nationwide, and then collect off of Nationwide in a settlement. Instead, it went silly. This video was adapted from my blog, Zalma on Insurance, which is free to anyone who clicks on the URL zalma.com/blog. You can also subscribe to my blog at the link, You can subscribe to these videos at rumble.com or at youtube.com, and you might also consider subscribing to my Substack publications and my locals community. If you found this video useful to you or your colleagues, please tell them how to subscribe to the blog and the videos. I appreciate your attention.